In 1600, the British East India Company arrived in India as a commercial enterprise. Operating under an exclusive royal charter granted by Queen Elizabeth I, the company functioned for over a century with one goal: maximizing trade profits. That focus shifted in 1765. Following military success, the company obtained the Diwani, rights over revenue and civil justice, in Bengal, Bihar, and Orissa. This transformed a trading corporation into a territorial power governing millions of inhabitants. Ruling this population required a formal legal framework. The British government intervened with the Regulating Act of 1773, marking the first step toward a central administration. By creating the office of the Governor-General, they began to supervise a corporation that had grown into a state. This diagram shows how Pitt's India Act of 1784 formalized the stool identity. It split the company's functions to create a double government. While the Court of Directors kept managing commercial trade, a new Board of Control oversaw all political, civil, and military operations. These initial acts were designed simply to leash a rogue corporation. By organizing the company's territorial control, the British Parliament unintentionally laid the foundation for India's modern central government administration. Over the following decades, the British Crown steadily absorbed the company's authority. The Charter Act of 1813 ended the company's trade monopoly in India and explicitly asserted the Crown's sovereignty over all territories. By 1833, centralization reached its peak. This map visualizes the Charter Act of 1833, which elevated the Governor-General of Bengal to the Governor-General of India. It stripped the governors of Bombay and Madras of their legislative powers, concentrating all civil and military authority into one central hub. The Charter Act of 1853 then divided this central authority into two functions. For the first time, it separated the Governor-General's executive duties from his lawmaking duties, establishing a dedicated legislative council that functioned as a miniature parliament. By 1853, the EIC had engineered a rigid, top-heavy administration that centralized all decision-making in Bengal and excluded local representation. This total consolidation of power left no room for provincial grievances, creating a systemic tension that was about to rupture. The 1857 Sepoy Mutiny was a widespread rebellion against colonial rule. The uprising served as a brutal reality check for London, shattering the illusion that a corporate entity could maintain stability over the subcontinent. In response, the Government of India Act of 1858 formally abolished the East India Company. All territories, revenues, and governmental powers were transferred directly to the British Crown, to be managed by a representative titled the Viceroy of India. Seeking to prevent another revolt, the British began reversing their strict centralization. The Indian Councils Act of 1861 restored legislative powers to the Bombay and Madras presidencies, initiating a gradual policy of decentralization to appease local leaders. As the Indian population pushed for political representation, the 1909 Morley-Minto reforms allowed Indians to join the Viceroy's Executive Council. However, it also introduced separate electorates, where Muslim members could only be elected by Muslim voters. To maintain the empire, the British conceded administrative power. By writing religious divisions directly into the voting laws, they planted the ideological seeds that would eventually lead to the country's partition. The experiments in power sharing continued with the Government of India Act of 1919. This act introduced diarchy, or double rule, in the provinces. It split administration into transferred subjects, like education, run by Indian ministers, and reserved subjects, like police, kept under British control. When the British attempted to expand communal electorates to the depressed classes, they met fierce resistance. Mahatma Gandhi undertook a fast unto death in protest, leading to the Pune Pact, protecting joint electorates while guaranteeing reserved seats. These administrative frictions led to the Government of India Act of 1935. This 321-section document abolished the failing diarchy system and introduced provincial autonomy, finally allowing the provinces to govern their defined spheres independently of central control. This diagram illustrates how the 1935 Act formally divided powers between the center and the provinces. It established a federal list for central authority, a provincial list for local governments, and a concurrent list for subjects managed by both. The 1935 Act laid down a detailed distribution of legislative power. It served as the structural skeleton of federalism that the architects of the future Indian Republic would eventually inherit. By 1946, the narrative shifted from British legislation to Indian agency. A Constituent Assembly convened in New Delhi, marking the first time a representative body of Indians sat down to draft the nation's supreme law. The Assembly relied on the country's most experienced legal minds. Dr. B.R. Ambedkar was appointed chairman of the drafting committee, tasked with translating the country's complex administrative needs into a unified constitution. The goals were defined by the Objectives Resolution. The members moved beyond seeking dominion status under the British. They mandated the creation of a sovereign republic that guaranteed justice, equality, and freedom for all citizens. The drafting committee faced the task of taking an autocratic framework designed for colonial control and rewriting it to establish a Bill of Fundamental Rights and universal voting for every citizen. The legal end of the colonial era arrived with the Indian Independence Act of 1947. The act ended British rule, proclaimed the lapse of British paramountcy over princely states, and transferred sovereign legislative power to the constituent assemblies. The immediate consequence of this act was the partition of the subcontinent into the dominions of India and Pakistan, a process that displaced millions and redefined the region's geography. To govern the nation, the Constituent Assembly adapted the administrative mechanics of the 1935 Act. When the Constitution of India took effect in 1950, it retained that federal structure, but transformed it by adding fundamental rights and universal adult franchise. India's constitution stands as a masterclass in historical synthesis. It successfully reverse-engineered 2 centuries of colonial architecture, stripping away the autocracy to build the world's largest democratic fortress. In the 1930s, leaders of the Indian independence movement faced a hard truth. Removing British colonial rule would leave a massive power vacuum, and simply evicting an empire meant very little if they didn't have a functional, self-governing framework ready to replace it. The idea for a constituent assembly to build that framework was first proposed by communist pioneer M.N. Roy in 1934. It took 12 years, but in 1946, the British government's cabinet mission plan finally initiated the process. The assembly began on incredibly shaky ground. It consisted of 389 indirectly elected members, and when they convened for their very first meeting in December 1946, the Muslim League immediately boycotted the session to demand a separate state. At the start, the group was fractured and still operating under the ultimate legal permission of the British Empire. This left the assembly with the massive challenge of agreeing on the foundation for an independent nation while lacking full sovereignty. Then, on December 13th, Jawaharlal Nehru stepped in to introduce the Objectives Resolution. This binding declaration committed the Assembly to proclaim India an independent sovereign republic and to legally secure social, economic, and political justice for all its people. That resolution gave a divided room a specific target. Before the immense mechanical work of writing the Constitution began, they established their philosophical baseline. By the middle of 1947, the geopolitical reality on the ground shifted. The Mountbatten Plan initiated the partition of the subcontinent, and the Muslim League members withdrew from the Assembly entirely to govern the newly formed Pakistan. This withdrawal dropped the Assembly's membership down to 299. However, the Indian Independence Act of 1947 gave this smaller group something vital: absolute sovereignty. They could now frame whatever constitution they wanted, completely free from British parliamentary oversight. With that sovereignty came an immediate logistical burden. The country needed a day-to-day government. To handle this, the Assembly split its schedule. They spent certain days drafting the Constitution and separate days acting as India's provisional parliament. To keep the operations distinct, they split the leadership as well. Dr. Rajendra Prasad chaired the Constitution-making sessions, and G.V. Mavlankar took the gavel when they met as a legislature. By operating as a single body wearing 2 hats, they kept a newly partitioned country running without descending into anarchy, while actively engineering its permanent legal system. The actual drafting of that legal framework fell to a specialized 7-member drafting committee, set up in August 1947 and chaired by Dr. B.R. Ambedkar. The committee began an intense period of academic research, studying the structural mechanisms of roughly 60 different countries to see what worked and what didn't. This visualization shows the funnel of their drafting process. Over 114 days of consideration, the broader public and assembly members proposed 7,653 amendments. The drafting committee actively debated nearly 2,500 of those amendments on the assembly floor. The assembly subjected every clause to an exhaustive stress test, bulletproofing the legal framework against future vulnerabilities. The final draft cleared its final hurdle on November 26, 1949, when the document was officially adopted and signed by the 284 members present. This chart compares the drafting timelines of different nations. You can see the framers of the American Constitution finished their work in about 4 months. India's process took nearly 3 years, 2 years, 11 months, and 18 days. Critics at the time pointed to this as proof that the assembly was sluggish and inefficient. Other detractors argued the assembly was essentially an echo chamber, skewed toward the majority Congress party and dominated by a class of elite lawyer politicians. But the actual roster shows deliberate, baked-in representation. The assembly actively included members from minority religions, scheduled castes, backward tribes, and 15 women, including leaders like Sarojini Naidu. In a massive country divided by deep linguistic, religious, and cultural lines, a fast process would have ignored those complex realities. That drawn-out timeline allowed them to build genuine consensus across a fractured society. The final result wasn't printed on an industrial press. The original Constitution was handwritten in a flowing italic style by calligrapher Prem Bihari Narain Raizada. While some articles took effect immediately, the bulk of the Constitution officially commenced on January 26, 1950. They selected that specific day to honor the 1930 resolution demanding Purna Swaraj, or complete independence. What started as a fractured committee operating under colonial oversight evolved through a 3-year intellectual marathon. The assembly successfully managed to engineer a democratic framework robust enough to govern a diverse subcontinent for generations. Before there are rules, sovereign power is dangerous. It is a boundless, volatile force with no physical edges and no internal constraints. To survive it, a political community must build a structure. They have to engage in what the Romans called constituere, the Latin root meaning to establish or to set up. What they establish is a constitution. Think of it as the foundational operating system of the state. It maps out the exact mechanical organization of the government. Crucially, it defines the power relationship between that newly organized governing body and the citizens it oversees. Political scientists describe this framework using a few different terms: the supreme law of the state, the basic structure of the polity, or the country's Grundnorm. Without this blueprint, a political community simply lacks the basic architecture required to function. But possessing a highly detailed blueprint does not guarantee a free society. Some of the most tightly controlled authoritarian regimes rely on these exact documents to dictate their state functions. There is a severe distinction between the physical text, the Constitution, and the active philosophy of limited power, known as constitutionalism. To see how a state actually operates, we first have to dissect the taxonomy of the documents themselves, and then examine the mechanisms required to restrain them. The text is merely the raw machinery of statecraft. To understand its impact, we have to look at how it is built. This animated matrix represents the baseline functions. First, it declares physical boundaries. Next, it establishes institutions and divides power among layers of government. It also encodes state identity, citizen rights, and developmental goals. For this structure to survive, it requires specific functional qualities. It needs brevity. A text weighed down with unwanted provisions creates immediate confusion when judges try to interpret its clauses. It requires definiteness and clarity. Ambiguous language increases judicial discretion and introduces dangerous unpredictability into the law. Finally, it requires adaptability. A successful constitution operates as a dynamic, living document, capable of adjusting to shifting socioeconomic conditions. The drafters walk a narrow tightrope. They must build a system rigid enough to establish absolute boundaries, yet flexible enough to survive centuries of pressure. Constitutions are classified along several axes. The first is historical formation, or evolution. An evolved constitution is the slow accumulation of practices, conventions, and judicial decisions. The British Constitution operates exactly this way, a cumulative historical framework built over hundreds of years. In contrast, an enacted constitution is deliberately drafted by a specific assembly at a localized moment in time. This photograph shows the Constituent Assembly of India, the physical gathering of lawmakers writing the Constitution. It is the ultimate example of a deliberately enacted document. The second axis relates to incorporation, dividing documents into written and unwritten categories. An unwritten constitution does not mean there is an absence of paper. It simply means the rules are scattered across various statutes and charters, lacking a single, unified codification. This document is the archetype of a written constitution. Consciously adopted by a convention, the U.S. Constitution incorporates its provisions into a single, binding text. The specific history of a state dictates whether its supreme law is dispersed across centuries of tradition or bound within a single volume. The third axis of classification, defined by Lord James Bryce, examines the method of amendment. This splits systems into rigid and flexible. A rigid constitution requires special, highly restrictive procedures for any alterations, creating a strict legal firewall between constitutional law and ordinary law. A flexible constitution, like New Zealand's, lacks that firewall. It can be altered using the exact same legislative process required to pass a local statute. These flowcharts illustrate the geographic distribution of power. On the unitary side, power concentrates at the national center, making regional governments subordinate agencies. On the federal side, national and regional governments possess independent, legally protected jurisdictions without top-down override. Some systems blend the two. The Constitution of India, for instance, is classified by Ware as quasi-federal, deliberately synthesizing federal division with unitary concentration. Legal amendment mechanics and the geographic distribution of power determine if a state can absorb internal political pressures, or if it will fracture under them. Elliot Bulmer identifies a final axis, classifying documents by their ultimate purpose, procedural versus prescriptive. A procedural constitution acts as a strict, neutral framework. It exists solely to define the legal limits of government power and protect democratic processes. A prescriptive constitution goes further. It attempts to impose a broad consensus on societal goals, demanding that public authorities strive to achieve specific developmental outcomes. This access proves that the text does not have to be a neutral rulebook. It can act as a targeted engine, designed to force a society toward a desired future. This brings us back to the opening paradox. A dictator can perfectly utilize a procedural constitution to seize total control, following rules exactly as written. Granting unlimited, arbitrary power to an individual or an institution destroys freedom, even if that power is conferred legally through a formal document. Closing this systemic loophole requires a mandatory antidote, the concept of constitutionalism. Political scholars define constitutionalism as the exact antithesis of arbitrary rule. It is a system that actively demands and enforces limited government. Possessing the physical legal text means very little unless the broader political culture enforces the philosophical limitation of that government's power. Louis Henkin identified 8 strict elements of constitutionalism. The foundation requires popular sovereignty, rule of law, and an accountable government. Internally, strict separation of powers and an independent judiciary. Finally, civilian military control, lawful police, and respect for individual rights. A constitution maps the cold architecture of the state. Constitutionalism is the ironclad operating philosophy ensuring MAC architecture serves the people rather than the architects.
When you look at the foundational blueprints of modern nation-states, brevity is the historical norm. Then there is the Constitution of India. This chart compares the core article counts of early Western constitutions. The United States operates on a highly concentrated 7 articles. Australia has 128. Canada sits at 147. When adopted in 1949, the Indian Constitution contained 395 articles, divided into 22 parts. After decades of amendments, it currently sits at approximately 470 articles and 12 schedules. It holds the record as the lengthiest written constitution in global history. This sheer volume drew intense contemporary criticism. Detractors dismissed it as a patchwork, a bag of borrowings, a hodgepodge of foreign ideas. The most severe accusation leveled by members of the Assembly was that the document was a little more than an amended version of the 1935 Government of India Act, a carbon copy of colonial legislation. Dr. B.R. Ambedkar, chairman of the drafting committee, confronted these accusations directly on the Assembly floor. He offered no apologies for examining other nations' systems, noting that the Assembly had framed the document after ransacking all the known constitutions of the world. The drafting committee explicitly sought out established democratic principles from across the globe, stripping away localized faults to extract the mechanics that would actually work on the subcontinent. The resulting density and the borrowed provisions were intentional. Operating a nation of such intense diversity required a meticulous, highly detailed synthesis. The architects began with a massive structural foundation already in place, the Government of India Act of 1935. More than half of the Constitution's provisions bear a close resemblance to this act. The framers retained its federal scheme, its judiciary framework, and exhaustive amounts of administrative detail. In modern Britain, administrative operations and political interactions are often left to established, unwritten conventions. The Indian framers chose to explicitly write them down. Relying on unspoken gentlemen's agreements was deemed too dangerous for a newly independent, fragmented population. The operational rules of the state had to be indisputable and highly visible. With the foundation laid, they needed an engine to run the state, the working relationship between the executive branch and the legislature. This network highlights two Western models. Left, the American presidential system relies on strict separation of powers. Right, the British parliamentary system functions on cooperation. India opted for coordination, adopting the British model to ensure executive responsibility to the legislature. But the framers did not install this engine without heavy modifications. The British state is headed by a hereditary monarch. The Indian system replaces the crown with an elected head of state, formalizing the nation as a republic. Second, the British Parliament is a fully sovereign body with absolute legislative authority. The Indian Parliament is not. The powers of Indian lawmakers are deliberately restricted by the written text of the Constitution itself and subject to review by an independent judiciary. The Assembly extracted the British mechanics of coordination, but installed Republican brakes to limit legislative overreach. This restriction introduced a tension recognized in constitutional law globally, finding the exact balance between parliamentary sovereignty and judicial supremacy. To manage this, India constructed an integrated, independent Supreme Court. It holds the power to strike down unconstitutional laws, but its scope is intentionally narrower than the United States Supreme Court. This textual analysis shows how that restriction is engineered in Article 21. The U.S. Constitution relies on due process of law. The Indian framers borrowed a concept from the Japanese Constitution, procedure established by law. By utilizing this specific phrasing, the framers prevented the courts from invalidating parliamentary laws purely on a subjective assessment of fairness. A similar precision governs how power is distributed geographically across a massive landscape, resulting in a system best described as federalism with a unitary bias. The word federation does not appear anywhere in the Indian Constitution. Instead, Article 1 defines India strictly as a union of states. This phrasing legally establishes that the nation is not the result of an agreement among independent states, and no state has the right to secede. The system's most unique feature is its central override mechanism, the emergency provisions found in Articles 352, 356, and 360. As this map illustrates, a declared emergency allows the president to instantly convert the divided federal structure into a unitary, centrally controlled state. No formal constitutional amendment is required to pull this lever. This mechanical shift grants states their regional autonomy during normal peacetime while prioritizing absolute national survival during a crisis. All of this raises an important question. If a foundational document is this heavy, detailed, and explicit, how does it survive the changing realities of future decades without snapping?
The answer lies in Article 368, the engine of constitutional evolution. It carefully blends rigidity with flexibility. This flowchart maps the three-tiered amendment process designed by the framers. On the first tier, certain baseline provisions can be updated by a simple majority in Parliament, passing easily like ordinary laws. The second and third tiers protect the core mechanics. Changing these requires a rigid special two-thirds majority, and for federal issues, ratification by half of all the states. This calibration gave Parliament the precise amount of flexibility needed to execute massive institutional upgrades that the original 1949 draft lacked. The clearest example of this evolutionary capacity occurred in 1992, with the passing of the 73rd and 74th Amendment Acts. Parliament used its amending power to integrate a completely new third tier of governance, rural panchayats and urban municipalities, a feature currently absent from other federal constitutions globally. If the legislature possesses such broad amending power, what stops a temporary majority from legally dismantling the republic entirely? The ultimate failsafe was established in 1973 by the Supreme Court in the landmark Kesavananda Bharati case. The ruling established the basic structure doctrine. It confirms that Parliament has expansive power to amend the Constitution, but it legally cannot alter its core architectural identity. The Indian Constitution avoids stagnation because it was never a carbon copy. By extracting, modifying, and balancing global administrative mechanics, the framers engineered a self-balancing operating system that successfully sustains the democratic framework of 1.4 billion people.